Farrell, thank you. Thank you very much for coming. And I just kind of lean in. You were the Chief Prosecutor at Lebanon.
Mm-hmm.
And unusual case.
Yeah, certainly.
Because all of them were in absentia.
Mm-hmm.
How much did you, if any, reflect on Nuremberg and the Martin Bormann case, which is the only one I could think of?
No, fair enough. The Martin Bormann case is the only case that we could draw on. It was the only case in Nuremberg that was in absentia. And trying to determine how to proceed in an absentia trial. In Nuremberg, they had the benefit of the other prosecutions, the other cases from which they could draw on the evidence. Well, in our case, there wasn't. There was no other cases. It was the one and only case. We certainly relied a lot on the understanding the case and its context. But since we applied different law, and we didn't apply war crimes, crimes against humanity, or genocide at the Lebanon tribunal, it was a case that took place under the context of Lebanese law. So it was more about a case of domestic terrorism, but trying to continue in a hybrid nature of these international tribunals that originated, obviously, over time from '93 with the Yugoslav tribunal, but reaching back to Nuremberg as well.
Did you find that, I mean, obviously you didn't have an actual defendant, but they had a defense counsel.
Mm-hmm.
That was assigned by the judge. How kind of weird was it, in the sense that, so unorthodox?
Completely. I mean, from our legal systems, by our I mean the common law legal systems, it's extremely unusual that you would ever do a case with no one sitting in the prisoner's dock unless you started the case with them and then subsequently they absconded. So to try to run a case without someone present required rethinking the way in which you approach the case, because it was really more about allowing the victims to have a voice and presenting the evidence for that purpose, as opposed to immediate conviction and liability because there was no accused present.
So did you really feel like it was a documentation, basically providing history through the course of the judicials kind of letting the evidence in?
That's an excellent question. I mean, when you start these trials, when we're used to prosecuting someone who's present, and we think of accountability from the perspective of actually holding someone accountable in person where they will eventually be sentenced and serve a sentence, you have to take the frame of reference away from that when in an in absentia trial. The in absentia trial becomes a means by which a factual narrative is created, whereby you're unveiling the truth and whereby you're hearing the victims' voices. Because the victims, though they want accountability, they also want the story told. And in the context of Lebanon, where there hadn't been any prosecutions, and there were a number of political assassinations or attempted assassinations over a lengthy period of time, not any of them really were brought to trial. This was an attempt where the victims could actually see what happened. In fact, once after we did the opening, there was a number of victims that were present, and they were in the body of the courtroom. And afterwards, they came up and were speaking, not directly to me, I was leaving the courtroom after arguing, but to other members of my team. And they said, as they watched the opening, this is something we never would have known. We never would have learned this. In fact, one of them said the route that the perpetrators traveled as they were watching Hariri and following him, that went almost by my house. And I had no idea that this was taking place in my own city. So it created a certain element where you felt that it was actually worthwhile, when we as prosecutors tend to look at whether we have the accused in custody. So it created a different way to look at it, which is the factual and historical narrative, which may never have been revealed if not for the trial in absentia. Now, let's be honest, it's probably the second best option. We would want the accused present, but it does mean that there is some value in this context where there wouldn't be the opportunity for that evidence to be heard or the voices of the victims to actually be heard.
Well, and just think of the Milosevic trial, where he died before there was a verdict. You had a verdict, and hence there was a record. that is now judicially sealed. There's an imprimatur of a sealed record. And I think of Milosevic, we had the trial, he dies prior to any conviction. I'm not sure what happens to the record.
It's a good question. I mean, the record still exists, obviously, and the ability of the public to understand what the evidence was. But that's not the same as ultimate determination. Conviction or acquittal, of course. It depends on the judge's decision. But an ultimate decision is one where there is some sense that this actually unveils the truth and that there is some finalization of what events really occurred, so that it has a historical record. The other thing is these tribunals, though they're subject to criticism, of course, they're a record that is kept for years. The Nuremberg Tribunal is still kept. We still look at it. When I was practicing in The Hague, I had the records and the judgment on my shelf. And these things meant a lot to those of us that were in practice, that we could look back on it and see that they existed. And there was a record of it, and there was a determination at the end of the day by the court. Whether it was acquittal or conviction, that's not the point. And so, yes, the Milosevic decision, and I was at the ICTY at the time, it was obviously somewhat difficult to accept that we wouldn't get to the final stages of a judgment and a final record of what happened. Our case was a little different. We didn't have the person in custody, but there is a final record.
Yeah. Well, for the camera, and I kind of glossed over it because we're kind of familiar, I am, but for somebody who watches this, give me a little backdrop of the Special Tribunal for Lebanon. Why was it even created?
The Special Tribunal for Lebanon was created by Security Council resolution, so it was by the United Nations. It was created as a result of an assassination that took place February 14th, 2005 in downtown Lebanon. Rafi Hariri, the former Prime Minister of Lebanon, was leaving the parliament buildings, was driving back to his residence, and on his way back in the middle of downtown, there was a huge explosion. The explosion was so great, for example, that a piece of the undercarriage of his vehicle was found on the second floor of a hotel across the street. Wow. And the result was not only the killing of him, but a total of 21 people and an injury of 221 people downtown Lebanon in the middle of a workday. But the assassination was of a prime minister with with an uncertainty as to who the perpetrators were, what the cause was. And he was a large political figure in the Middle East at the time, and there was an institution established, a hybrid institution that was based on Lebanese law, which had Lebanese staff and international staff for the investigation and prosecution of that assassination and other assassinations characterized as political assassinations in Lebanon during that time period in 2005.
Your source of evidence, I'm just having followed it, but a lot of phone records, a lot of kind of interesting use of cell phones and stuff like that. And I'm not sure that's been used before.
No, it was, because of the nature of the case, we had to look for other sources of evidence that were not the traditional forms of evidence. There wasn't a lot of witnesses that came forward. The court ultimately found that the perpetrators were associated with Hezbollah, and there were a number of attempts to reach out to witnesses who were concerned about testimony or witnesses who didn't know. It was a completely it was a very disciplined attack with very strict rules of conduct by those who carried out the perpetration. We were able to identify the telephones that were used because those telephones were constantly in the vicinity of Hariri. So as Hariri, for example, left from his residence and flew out of the country, we were able to identify, based on the telephones, vehicles and telephones that followed him right to the airport, and then they shut off the moment his plane took off. Then when he landed, 2-3 days later, back in the country, those telephones were activated at the airport, and then those telephones by cell towers, you could follow those telephones that went all the way and stayed outside of his house and followed him. Now, the discipline that was used with those telephone users, messages by telephone call were on average less than 30 seconds. Never a text message. So there was no way of determining content of the message itself. And once they finished their surveillance, they'd turn off. One set of phones would follow Hariri wherever he went, and the moment Hariri stops, the phones would turn off. So you could never follow the phones to the point where they went home, wherever home was. So you had to find what was called the mission phones, the phones that were used to follow him, and then track all other phone data which would coincide with that phone so that you could look at what was the clean phone. Someone was carrying 2 phones on them. So they'd have the phone they'd use for their own personal use, and then they'd have the phone for mission use. And you would, over time, it took 6 months, over a 6-month period, they could eventually find 2 phones that used the exact same cell towers within the same time period, within a certain time period, and those 2 phones never called each other. And those 2 phones mirrored each other throughout the country, even to southern Lebanon, and even into areas where the prosecution could not get access. And eventually, by looking at the phone that was attributed to them, their phone that they would use to phone their family, you check the top 10 contacts. So you look at the contacts, the top 10 contacts on the clean phone, and you'd, from that top 10 contacts, figure out who the user was. Now, all the users use full subscriber details, even on their clean phones. And then on their mission phones, there were no subscriber details. They were burner phones or first use phones. But if you could match the clean phone with the phone and follow it throughout the whole country, that these 2 phones were always in the same place at all the same time and never called each other, then you could attribute the mission phone to the person who was carrying the clean phone. Wow. And through that evidence, we were able to track the exact patterns of conduct, and then by the clean phones attribute it to individuals. I mean, there was one incident that I can speak about that's on the public record, where one of the perpetrators used his phone that was attributed to him to contact someone at the same location of his mission phone. And he got in a car accident, and he had to get a tow truck. And it was clear he was going somewhere as part of his mission, because 2 other phones that we'd been tracking suddenly stopped what they were doing and waited for him, and one of them came to get him. And he phoned to say that his car had been in an accident, but he had to phone a tow truck company and use his actual name and his actual ID. And the tow truck company came and got the vehicle, but then he, on his mission phones, contacted someone else who came and picked him up, and were able to attribute that phone. So by going to the tow truck company and finding out who was the person that was at the same place using the same phone that was carrying the mission phone, we're able to actually attribute the mission phone to him, and then follow that mission phone for 4 more months to the point where it was the phone that was in use at the time of his assassination. And all those phones, all the mission phones, they all shut off within 1 minute of the assassination and were never used again, and they all had money left on them. And from that, the court was able to draw inferences to the use of the phones and who the perpetrators were without any direct evidence from a witness.
Wow.
That's
riveting.
Well, it was the investigators and the analysts that did the work that did such an amazing job.
Now, because this is not direct evidence, other than the phone records, of course, and it is by inference, as you said, how did the court rule generally, but kind of how to deal with this evidentiary stuff?
That's a good question. The court was careful and had to be careful because it wasn't direct evidence. No one was able to pinpoint who was at the crime scene or who was the one that activated the assassination bomb. But what they did was they took the evidence. It really was over a period of time. It was over months that these phones were activated and followed Hariri. And they came to the view that there was no other conclusion, that first it was the person carrying the phone that was unattributed, that it had to be the person carrying the clean phone. It couldn't have been any other person. So even though that was just one step in the chain, it really required to be proved beyond a reasonable doubt. Yeah. Then once you determined that that person was the person carrying the phone, then you had to prove beyond a reasonable doubt that that phone was involved. And then you had to determine that based on the activity of the phone, which is attributed to the person, that person did it for the purpose solely of the assassination. So each step was extremely difficult to prove, and the court, to their credit, had to be very careful to get there, because on the basis of phone activity, you actually not only identify the accused, you attribute a mens rea, a mental element to them, that was their intention based on the conduct that you infer was taking place by the activity that you can infer from how the phone acted, where it went, and what it did, including the person that was carrying it.
So the judgment of the court was what?
The original judgment of the trial chamber was that they convicted, there was 5 accused. They originally convicted one person. One person had died, and they acquitted 3 persons. The prosecution appealed in relation to, of the 3 that had been acquitted, the prosecution appealed 2 of them. And the person who had died, who was proven to be a senior member of the military wing of Hezbollah, we argued that that person would still be an unindicted co-conspirator and still be a member of the conspiracy. It went up to the appeals chamber, and on appeal, they upheld the prosecution's appeal. They entered convictions for the 2 people that we appealed, and they said that the individual, though he had passed away and obviously could not be convicted, they said that he was the senior member at the apex of the telephone network and therefore the apex of the conspiracy that resulted in the death of former Prime Minister Rafi Hariri.
Was the Hezbollah a named defendant?
No, there was no attribution to Hezbollah as either an organization or to the head of Hezbollah at the time. The use of the evidence of these individuals being associated with Hezbollah was more to demonstrate their connection with each other, and that even though they may not have been under orders, or it wasn't proven, that could be considered in terms of what the motive was, which was at the time, the theory was that the Rafi Hariri was taking a position contrary to the status quo, including in relation to the role that some of the parties played. By parties, I mean external states and Hezbollah, and he was taking a position more for the liberation and independence of Lebanon from those forces, and therefore it was conceivable that they acted, whether they acted under instruction or direction couldn't be proven, but they acted for that purpose to prevent Hariri from taking those steps, and that their association with Hezbollah actually was one of the things that showed they were connected. Because when you have phone calls and individual phones that are acting, you have to demonstrate they're acting in concert, that they're not random phone.
Was it conspiracy? Is there a conspiracy charge to this?
Yeah, there was a conspiracy charge and a commission charge, and they were convicted of both.
You satisfied?
Satisfied with the outcome, and very satisfied, I would say, with the ability to demonstrate the case through telecommunications data, which was a first. And telecommunications data from 2005. Now our phones collect much more data, as we're all aware, and you can you can identify and profile people much more so through telecommunications data now. Back then, there wasn't the same data that was collected from telephones. So a conviction based on telecommunications data as the primary base of evidence was a huge success. And some credit has to be given to some of the Lebanese that were involved in this, including some of the Lebanese officers who were originally looking into this. One of them who was assassinated himself was Hamid. Completely satisfied? No. No, the accused remain at large. The efforts that were made to arrest them were not successful. The court had found to do the trial in absentia that they must have been aware and that they must have been notified of the crimes for which they're charged. The defense counsel, to give some credit to the good work done by defense counsel, they had to defend a case without a client. And ultimately, the case is finished and the tribunal is closing, but without an accused ever serving a sentence or without an accused ever being arrested. That is something that would have to be considered as something that would require some improvement. And it is relevant when we're talking today in the current situation of Ukraine, and there is discussions about a trial in absentia. What has to be considered is what the objective is of the trial in absentia. If the objective, as we started saying at the beginning, is to unveil the truth or to try and have a factual or historical narrative, and that's the objective you're willing to live with, then it is a very good vehicle for achieving that. If your concept of accountability is something more than that, which is you can unveil the truth or hold someone accountable through historical narratives, but hold them accountable by arresting them, trials in absentia might be a second best option. And that's the one thing that I think has to be considered in the future, looking back on the legacy of the STL as to its value, in its true value, both in both the respects of unveiling the truth and having a true historical narrative that might not have been achieved at a high level. We're talking about at a level of proof beyond a reasonable doubt, but also whether that's the sense of accountability we want to strive for when the person is never brought to justice, in the sense that they never personally are brought before the court or within the jurisdiction of the court.
Do you know where they are?
No, there's evidence that we'd received as to where they might have been, and the one who is deceased, the one who during the middle of the trial we stopped the case against that person but proceeded on them as a co-conspirator. That person was in Syria and was subsequently killed in Syria in armed combat, fighting for the Syrian government at the time, and then was brought back, obviously, after being deceased, to Lebanon. So there was at least the evidence of the most senior member of the conspiracy being in Syria at the time he was killed.
How did you get in this business? Were your parents at all lawyers or anything like that?
No, I don't come from a family of lawyers. Neither of my parents were lawyers. I was a practitioner in Canada, a prosecutor, and after about 9 or 10 years, decided I wanted to consider doing something different. So I joined the International Committee of the Red Cross as a delegate through the Canadian Red Cross. I ended up being sent overseas with the Red Cross, worked in Bosnia at the end of the conflict in 1996, again, and stayed in Bosnia till 97. Then at the end of the 2 years in Bosnia, the Red Cross told me they send me to a country that wasn't in a conflict or post-conflict environment, offered me another mission, so I got another leave of absence from my job in Canada as a prosecutor. Went to Ethiopia, and 3 months later the Ethiopia-Eritrean conflict started, and was back in a conflict zone, trying to deal with prisoners of war and trying to track down missing persons and trying to get access to prisoners of war to get messages to their family, humanitarian aid. And then after that, I decided I was thinking of returning to Canada, and got a call from the ICRC to come and litigate against the ICTY. The ICTY prosecutor's office was intending to call an ICRC delegate as a witness. Red Cross doesn't want its delegates working on the field to become witnesses or people who give evidence. So I ended up going back immediately to the ICRC and was co-counsel on a case against the ICTY, claiming that the ICRC had privilege under customary international law, and they couldn't call the witness, and that they couldn't take any ICRC delegates as witnesses. Yeah, and we won. We won before the ICTY, and the ICRC was given a form of privilege, and the prosecutor at the time, Louise Arbour, was not permitted to call the ICRC delegate to testify about what happened in the prison in Bosnia. And then after my exposure to that, I thought I'd like to get back to doing criminal law, but I'd like to do it at an international level. So then I applied and was fortunate enough to get hired at the ICTY, and then worked at the ICTR, and then moved on from there.
So was the chief at the ICTY, was that Louise at the time?
Yes, when I was first hired, it was Justice Arbour, Louise Arbour. Okay. Then I was there through Madame Del Ponte, Carla's reign for 8 years, and then I stayed on and worked as Prosecutor Bramert, Serge Bramert's deputy, for 4 years before moving on to the Lebanon Tribunal.
Well, you went to Rwanda, did you say?
For a while there, you may recall, but at the period of time, the Rwanda Tribunal and the ICTY, the Yugoslav Tribunal, had one prosecutor. So during that time, there was only one appeals section, one prosecutor's appeals section. So that section did all the appeals at the Rwanda Tribunal. So we did Akayesu, Kabanda, Baglashima, Baragwiza, Musima, all those cases with our colleagues from the Rwanda Tribunal. So I did most of those. And then after the two tribunals split, I went up to the ICTY and then carried on doing a number of appeal cases and argued cases in Kordich, Blaskic, Frunja, Alexovsky, Kirstich, and a number of cases there as counsel for the prosecution in the appellate, the appeals chamber.
Your paths didn't cross officially with Hassan Jallo.
No, but I know Prosecutor Jallo quite well, because when he took over for the ICTR, we were still working and advising. So I would travel down to the Rwanda tribunal during the period they were setting up their own appeals section for the prosecutor's office, and I had a real pleasure of working with Hassan and getting a chance to see him, to meet him.
So you're into this for about 25 years. Is there a reflection if some law student comes up to Norm Farrell, maybe they have today, and said, "I'd like to do what you do"? How would you advise them?
It's a different time and place now than it was when we started, but a couple things I can think of. Obviously, there are courses now today that students can take, and what we looked for, at least when I was doing the hiring at the Yugoslav and the Lebanon Tribunal, was genuine interest. There's lots of smart people out there, but what you really want is someone who has a genuine interest, because they're the ones that will put in the extra effort, that understand the concerns of the victims, that that are fair, that understand that the defense has a role to play as well as the prosecution. So those students that take the courses, but also attend conferences on their own, or maybe writes an article, and it doesn't have to be an article in the law school journal, it can be an article in the local paper or the local bulletins. Those students that demonstrate they take that little extra step to show that they're generally interested in the area and that that's where they want to move forward on, those are the students that, at least when I was looking at the students and we were doing our hiring, were the ones that were given the leg up. No, there's lots of very good students, fantastic students, and it's great that they're all interested. But the ones that show a genuine interest and make that extra effort, many have said, "Oh, you've got to do an LLM." And an LLM does help, no doubt about it. But we weren't hiring people based on LLMs. We were hiring people based on the fact that they did well at school, they obviously had the requisite knowledge, but they demonstrated a genuine interest in this field. This field, like many fields, people can have passing interests. It's in the news. Ukraine's an important issue that we as an international community have to address. But it's not the people with the passing interest that we want. It's the people that have an interest from Nuremberg until today. And those students that demonstrate that are the ones that are the keepers.
Did you, part of back to Lebanon for a second, did you broadcast that? Was there a sense of trying to educate the public as a result of what the evidence that was being presented?
There was an attempt, and there was an outreach program with the Lebanon Tribunal, and in fact the outreach was quite successful in a number of ways. One of them was that they set up an inter-university program. So to get a number of universities in Lebanon to agree to come together, because some of them are from different background, different sectors of the society, to get them to come together was a huge achievement. So the tribunal with the Asser Institute in the Netherlands brought together a number of universities to teach a course on international criminal law. So the students from a number of different universities came together, took the course, and we would go down. I went down 2 or 3 times to lecture at it. The other members of the defense and the president and others went down and lectures at it. And to have the Lebanese students in Lebanon at a course on international criminal law where their focus is about what happened in their country, that became not only an educational tool but an outreach tool. They're obviously the youth, the future, and to get them from different backgrounds and different religious groups that came together to try and understand it. And of course, there were times they were critical of it, but they were then given an avenue to learn not only the law, but the actual application of the law to the cases and the facts, which became a tool for them to be educated. Then there was a number of other outreach efforts made. In any society, and Lebanon was a society where people had different views about the value of the tribunal and what it represented, the attempt at outreach may be limited, but there certainly was. And the outreach office was based out of Lebanon. They weren't based out of The Hague. They were down in Lebanon, and the head of the outreach program lived there full time, met with a number of institutions, did a ton of outreach. The extent it is successful, it's hard to tell, because the society itself had different views, and the society was split on the value of the tribunal and held certain solid views or views that were fairly strongly held. But like other institutions, part of your success is only in the outreach.
What's the question I should be asking Norm Farrell that I haven't asked?
I can't really think of any. I think the question that comes to mind is, where are we going in this field of international criminal law? And now, as we've discussed, I'm now working from the domestic side. I'm working from the side in Canada on the domestic implementation. It's a different perspective in terms of what we do as an international community on accountability, and bringing the international aspect and the knowledge that we have back to a domestic jurisdiction, I think is hopefully valuable. And the encouragement by taking the knowledge and the experience we have back to domestic jurisdictions to have domestic accountability, I think, is one of the ways that we're going to move forward. I think it's fairly evident there will not be the proliferation of international tribunals that there once was, that the ICC is going to play a more predominant role with the ability of the Security Council, if it's not deadlocked, to refer cases to the ICC. The ICC has another opportunity to play a role, but ultimately, as I think all of us that work in the field know, the ultimate goal is not to have an international criminal court and to have domestic prosecution. So I think we need to start thinking about that, as well as the mechanisms that the UN General Assembly has established, that we have to look towards where we're going in this field, and that is moving more towards accountability, hopefully in the domestic level, that those of us that have worked internationally can continue to, or hopefully continue to contribute to.
You contribute much. Thank you, Norm Farrell.
Thank you very much for taking the time.